Good afternoon, everyone. Welcome to another edition of our After School Special, a weekly webinar series. My name is Heather Edwards. I'm an attorney with the law firm Edwards, Stevens and Tucker, and we're super excited to bring you another webinar on a special education legal topic in partnership with the El Dorado County SELPA. Thanks so much for joining us today. As usual, there's a link in the chat to the handouts if you want a copy of the slides, and please feel free to put questions in the Q&A section, and we will make sure at the end of the presentation we'll shut off the recording, and then we'll have a few minutes to make sure that we answer any questions that you may have. So let's go ahead and get started on talking about an interesting topic that has there's a lot of legal disputes over residential placements. It's definitely an area that we see a lot of litigation over in our firm because it is one of the most highly restrictive placements that you can put a child with a disability. And we know that there's a lot of different factors that go into whether or not a residential placement may be appropriate and necessary for a student to receive a free appropriate public education. It really does impact a small percentage of students. So those of you who are probably attending today, you may have students who are in residential placements, or you may have a request for a residential placement and kind of trying to figure out the best way to navigate that, because usually it is a very small percentage of our children with disabilities who may need such a restrictive type of a placement to actually be living at their educational placement. So we're going to talk a little bit about some of the legal framework and some cases to just kind of give an analysis of what other courts and hearing office decisions have come out regarding residential placements for our students. So what are we talking about when we're talking about a residential program? Broadly speaking, it's some sort of residential program or placement where a child is actually placed away from his or her home. And whether or not it's actually an educational placement is really the core question in a lot of the cases that we see come through the courts. In some cases, the student may need to leave the state in order to attend school in a residential program, which is a very big decision for families and for school districts to decide to remove a child from their home and place them in a location out of state. I know that there had actually been recently a lawsuit filed against the California Department of Education for lack of in-state residential programs that meet students' needs, particularly for those students aged 18 to 22. And what do we do for those students who still need special education and are still eligible up until age 22, but we just don't have very many residential programs that are available within California. So very often schools have to look to outside of California for placement potentials. And even those placements out of state, we're hearing more and more in our office about how they don't have any space available in those programs right now. And so sometimes schools are having to kind of cobble together something that kind of resembles some sort of interim program to provide support for the student until space opens up in one of these residential programs. Residential placements are very costly, even compared to the most expensive non-public school placements that are here in California, because we are also looking at paying for 24-hour care in terms of the education and the room and board and the non-medical related expenses for the student. And again, they are among the most restrictive educational placements that are available to students with disabilities. Most often they are not able to interact with any typically developing peers in these types of placements. Another question that comes up a lot of times is who's actually responsible for a residential placement, particularly when we have students who are involved in the dependency side of family court. So perhaps they're a foster youth, or they have social workers and child welfare workers that are involved. And then how do we decide? And oftentimes questions comes up for LEAs about residency or the responsibility for a placement for such a student, when maybe some of the problems are also because of the student's home environment as opposed to for educational reasons, or even if the student is involved in the delinquency side of juvenile court and is involved in the probation system. And if a student maybe is incarcerated and may need a residential placement, again, questions arise oftentimes about who is responsible for making that placement, whether it's the educational agency or the probation department, for example. So it definitely comes with a lot of unique issues when we're talking about residential placements. We know that IDEA, the federal law that governs special education to our students with disabilities, requires that local educational agencies have a continuum of alternative placements available to meet the needs of children with disabilities for special education and related services, which may include placement in a residential program. More specifically, IDEA has this regulation that says if placement in a public or private residential program is necessary to provide special education and related services to a child with a disability, that program, including non-medical care and room and board, must be provided at no cost to the parents of the child. So the key questions there that I highlighted, or the key phrases, are that it has to be necessary, and what's considered medical and what's considered non-medical. It used to be, and it still generally is under an older decision, the Tatro case, where there was a real bright line rule between what was considered medical and what was considered educational. And anything under that Tatro decision that requires a licensed physician to implement the service would be considered a medical service. And only those types of services that required a licensed physician would be a medical service. Anything else that could be provided by a non-licensed physician, which could be school nurses, which could be school psychologists and other types of special ed related service providers, would be considered a related service if it was necessary for the student to benefit from their special education program. And so that bright line was, is a doctor required for this service? If so, it's medical, but everything else could potentially fall within the responsibility of a local educational agency as being not a medical service. So a local educational agency's duty to offer a residential placement to a student with a disability really depends on whether or not the student requires it in order to receive FAPE. That is always the question, is what does the child need in order to receive a free, appropriate public education? We know from the Andrew F. decision, and before that, the United States Supreme Court decision in Rowley, that is the student's IEP, which includes educational placement, reasonably calculated to enable the student to make progress appropriate in light of the child's circumstances. That is the substantive FAPE standard, the question that we have to ask about whether or not the student has an IEP that's reasonably calculated to allow them to make progress in light of their circumstances. And if the answer is yes, that may or may not include a residential placement. And so those are the kinds of conversations that our IEP teams have to have, particularly when we're looking at maybe offering a placement in a less restrictive environment, like a non-public school or even in a school program. But the parents may be seeking a residential placement, and we have to look first at whether or not the school has offered an appropriate IEP. So the Clovis Unified School District Ninth Circuit case from 1990 helped us here in California, who were part of the Ninth Circuit, come up with somewhat of a framework. And what does it mean in terms of where do we draw the line in terms of what is necessary for residential placements? And essentially what this case said was, in order to determine whether a residential placement under IDEA is necessary to provide the student a free, appropriate public education, the analysis must focus on whether the residential placement is necessary for educational purposes, or whether the placement is in response to some sort of medical, social, or emotional problems that's very separate from the learning process. So the problem with that is that it's still very subjective, because so often our residential placements are for students who have significant mental health concerns, significant behavioral concerns, and the intertwining of those medical, social, emotional problems really start to get intertwined with those educational considerations. And so those are the things that it's very difficult sometimes for IEP teams to pull those things apart and really have to focus on, is this necessary for educational purposes? And that is really the question that our teams have to wrestle with. So I wanted to go through a few cases for you to see kind of how some of the courts have ruled on this issue. This was a Ninth Circuit decision from 2019, which really focused on whether or not it was a medical placement for medical purposes rather than for educational purposes. So what happened here was, for about 2 years before the parents unilaterally placed the student in a residential facility, the student's grades were dropping dramatically, and he had received about 20 or so disciplinary offenses during that 2-year period. The district had not offered to formally reevaluate the student during that 2-year time frame, and the IEP essentially had remained the same throughout that 2-year period. The district was arguing that the student's truancy, their lack of attendance, really excused its failure to offer an appropriate IEP, that they had made the services available to the student if only the student would have come to school to avail himself of the supports and services that were made available to him. So the parents sought reimbursement for their unilateral placement of this student who had ADHD, oppositional defiant disorder, and schizophrenia in a residential placement. The district was arguing that the placement that the parents had selected was solely due to medical needs, because the student was actually able to perform well academically whenever the student's medical conditions were under control. The district said that they believe that the focus of the residential placement that the parents had selected was more for serious medical intervention for students' mental health. That the student's mental health had deteriorated so much that the parents placed the student in residential, and that this was really more of an acute care type facility, and that the district was arguing that it was really predominantly a medical placement because the student's mental health had deteriorated so much over the 2 years. What the court said here, though, was that the support services that the student was receiving while at this residential facility included psychological services, social work services, therapeutic recreation, counseling, and medication management. All of those services, which are considered related services under IDEA, and the court said that they believe that these were all necessary for the student to receive a free, appropriate public education at this time. And they said that those services were needed in a residential setting to address truancy and the student's tendency to elope, which was significantly impeding his learning. So again, here you see, this is a prime example of where we have attendance issues and the students eloping issues, which may start to impact the student's education. And so the question oftentimes is, can the student be educated in a less restrictive environment than residential placement? A lot of times the arguments from the student side may be, yes, but how are you going to get the student to attend school, right? We may have an appropriate program for the student where if the student were to attend, it would be appropriate, but perhaps the student's mental health conditions are such that it's going to be impossible to get the student out the door and actually get them on a bus and get them to participate in a school environment, which requires this 24-hour umbrella type of a facility where the student's living where they have to get educated. And so that having that continuity between home and school environment is really what's necessary for the student to receive an appropriate education. Another good example of a case where residential placement was actually deemed not necessary to meet a student's educational needs was this case out of the Ashland School District, which is another Ninth Circuit case. And this was a case where the student was a female. She was eligible for special education due to ADHD. Her needs included that she was very distractible in the classroom. She had difficulty with completing tasks, with working independently, with organizing her assignments. She did receive A's and B's when she completed her assignments and turned them in on time, but she really consistently struggled to do so. And so because of that, she was earning primarily C's and D's. The IEP that the district had put together required specially designed instruction and counseling support. As a freshman, the student met with the counselor at school and discussed her parents' divorce, which was putting some challenges on her, and that she had begun dating a student who allegedly had forced her to have sex with him. Around this time, the student started showing some signs of depression. The district decided to reevaluate the student at this point, and the psychologist determined that the student's ADHD was not having a significant impact on her classroom performance. So the IEP team continued with her existing IEP and the services that had been put forth previously. The student finished her fall semester of her freshman year with 1A, 3 B's, and 2 D's. January of her freshman year, the student stayed late one night at the home of a custodian who worked at the high school. All kinds of red flags going off there, right? After the mother complained to school officials, the district reassigned the custodian to a night shift and demanded no further contact with the student. At that point, the student began to engage in some self-harming type of behavior, and a psychiatric nurse actually diagnosed the student with having adjustment disorder. During February of her freshman year, the parents decided to keep the student at home, and the district started providing a home instruction, home tutor type of a situation to her. She came back to school in March, and she finished her freshman year with 2 B's and 3 F's. During the summertime, the student snuck out of the house several times to go see male friends. So in September, at the start of her sophomore year, the mother informed the district that she was considering placing the student in a more restrictive program because of her risky behaviors. The district convened an IEP team meeting. The teachers were reporting that she participates in class, she receives A's and B's on assignments that she completes, and the director of student services reported that she, by and large, was successful at school. The district recommended that the mom look into community resources about how to try to set some limits in the home environment. Apparently, the student continued to sneak out of the house and be dishonest with her mother. So the parents decided to withdraw their daughter from the district, and they enrolled her in a private residential facility in Oregon. The student was expelled from the Oregon facility because she was caught having sex with another student at the residential placement. Then they enrolled her in an even more restrictive clinical all-girls residential facility in Arizona, and the parents filed a due process complaint seeking reimbursement from the district because of the district's failure to provide a free, appropriate public education. The court here in this case said that the student did not require a residential placement for any educational reason, and they denied the parents' request for reimbursement. The court really relied heavily on the fact that she had earned good grades when she managed to complete her work, that she was not disruptive in class, that she was capable of benefiting from the education that had been provided by the school. And that really the primary focus that prompted the parents to place the student residentially were her risky behaviors outside of school. So despite testimony from the residential facility representatives that the student was incapable of succeeding outside of the residential facility, the court determined that it was not warranted. So you'll oftentimes see this challenge where there may be things that are happening in the home environment, like sneaking out, engaging in risky type behaviors that the parents don't approve of, they're very concerned. But what the courts have said is that, those kinds of behaviors that are primarily happening in the home environment, if it is not affecting the school environment, if the student's attending regularly and that they're not having somatic complaints and trying to go home every day, if they're still able to keep it together and they're able to access their education, generally speaking, residential placement would not be warranted, like in that Ashland case. The common thread really where a residential placement might be warranted is that the student must demonstrate that he or she is unable to benefit from his educational placement or unable to make progress toward meeting their goals unless they're in a restrictive environment like residential placement. And this can be the case even if the behaviors at home have resulted in psychiatric hospitalizations. So only where that student's behavior from home is impacting their ability to function in the school environment will courts generally find that an IEP-based residential placement was warranted. So even when we're seeing hospitalization, that may be a reason to dig a little deeper, maybe offer to do some updated assessments if we're seeing that a student has been hospitalized. But again, it's where is that line where it starts to impact the student's education and whether or not there may be residential placement warranted. In terms of students who may attempt or threaten suicide, obviously those are very serious concerns for families and for our school agencies. Generally speaking, suicide threats that are attention-seeking behaviors are distinguishable from the serious potential for committing suicide. Usually only the latter is going to justify 24-hour type of supervision that's available in residential facilities. So even actual or past attempts at suicide would be taken very seriously when we're deciding what type of educational environment is necessary for a student. So for example, this case here, this Montgomery County case held that the student's actual suicide attempt by drug overdose did not require the district to pay for residential placement when the placement was for emotional rather than for educational reasons. But these are very tough calls to make for schools, for parents, and for hearing officers, because as a hearing officer, who wants to be the hearing officer that denies a request for reimbursement or denies a placement, and they're, I'm sure, human beings and very concerned about what the outcome could be if the student is not appropriately supported. In terms of truancy issues with residential placement, standing alone, just having attendance issues, truancy is not considered a basis by itself for residential placement. It's always going to be about what are the reasons underlying those truancy and attendance kind of behaviors, and whether the student's absenteeism is interfering with the student's ability to obtain educational benefit in a typical school setting. In this 8th Circuit case from the independent school district, the court had accepted some results of an independent educational evaluation, which said that the student could not receive educational benefit until her emotional and behavioral issues were resolved, and that the residential placement offered a high degree of structure and support that the student needed, and that her previous truancy and disruptiveness prevented her from making progress in the district's self-contained classroom. And that there was consensus that the student would be unable to obtain educational benefit in any other setting except for residential. And that's really what IEP teams would have to say in order to offer such a restrictive placement. Child find concerns also come up a lot when we're looking at residential placement type cases. So this was a case that just came out last year from the Office of Administrative Hearings from the Sequoia Union High School District. And here we had a 10th grade student who excelled in school, maintained A grades, and mostly took advanced placement courses. In May of 2020, her anxiety and self-harming behavior caused parents to consider inpatient mental treatment programs. The parent informed the student's teachers and her counselor that the teen was really suffering significantly from mental health issues, and they asked if the teachers would excuse her from some of her assignments. The teachers accommodated and excused her from those assignments, but they didn't ever make a special education referral. At some point, the student stopped attending classes, and then the parents placed her in a residential program. October of 2020, once the student had already been placed in the residential program, they did offer to do an evaluation at that point. The parent filed a request for due process, seeking reimbursement for their private placement. And the hearing office said, yeah, this was a child fine violation. The district said, hey, but the student wasn't having any sort of academic or behavior concerns that would have triggered their child fine duty to do a referral for an assessment. But the court said, or the hearing office said here, that once the parent informed the teachers and the counselor of students' anxiety and self-harming behaviors, and the student stopped attending class and stopped turning in work, that was enough, that the district had knowledge that the student at least needed to be evaluated for special education eligibility. So you can see that the threshold for child fine is very low. And as soon as it started to impact the student's education by not coming to class, not turning in work, that was enough. And so they ordered the district to reimburse the parents about $80,000 for a psychological assessment and tuition at a residential treatment center, as well as travel costs to get the student to the placement. So you can see there can be hefty price tags associated with this, and likely there were attorney's fees that were going to be owed as well. The other thing that comes up, as I mentioned at the beginning, is sometimes who's responsible. What agency may be responsible for a student, particularly when a student is already involved in the delinquency or dependency court system through probation or child welfare services. This came out of the Ninth Circuit a couple of years ago, and it was about a situation where the student had been a ward of the court who had been removed from the home from Child and Family Services. She was a 17-year-old girl. She had been part of the Department of Child and Family Welfare Services since she was 11 years old. And they were responsible as that agency, right, for making sure that the student was being given appropriate housing and that they were meeting her mental health needs. Through the school district, the student also qualified for special education services under the category of emotional disturbance. The juvenile court had ordered DCFS to provide the student with permanent placement services, and they had actually placed her in a series of different residential facilities. Throughout this time, several IEP meetings were convened, but none of students' IEPs called for a residential component to any of those DCFS placements. And the student's district of residence did not consider whether residential placement was necessary for educational purposes or what type of residential placement would provide the student with a free appropriate public education. So again, DCFS had placed the student in a locked residential treatment facility for mental health pursuant to a juvenile court order. So the student had already been placed by DFCS in a residential placement. But the court said here, and this went all the way to the Ninth Circuit, that students' IEP team still has an independent obligation to consider whether or not she requires residential placement for educational reasons. That the two agencies, DFCS and the local school district, have very different criteria in determining the appropriateness of residential placement. So they're looking at it through two different lenses. And that just because the student was placed by DFCS in a residential facility for housing purposes and mental health purposes didn't relieve the district of its obligation to at least consider whether they also needed to offer that through the IEP process. So the court said that the district had improperly failed to consider whether residential placement should be part of the student's IEP, even though they had already placed the student at a locked residential facility. So at least IEP teams should still consider whether or not they require it for educational reasons, even if you're aware that the juvenile court has ordered residential placement to be funded by some other agency. Interestingly, the court made special notice to not take a position about which agency would ultimately be responsible for paying for it, in the event that you had two different agencies that were recommending residential placement for different reasons, they kind of said that that's between you all to figure out whether or not, if the school district offers it through the IEP and DCFS offers it through the court system, who ultimately would be responsible for paying for it. So they didn't ultimately say so. Obviously, the IEP process, we can offer it, but we couldn't certainly go against any sort of court order that requires a placement for other reasons. However, the probation officer or the student's social worker may bring that information to the court to say, hey, the student's IEP team believes that she requires a residential placement, and the school is willing to fund that as well. So those are those interesting kind of cases that that come up from time to time. A lot of times, some of the issues that come up with this is also substance abuse treatment. So LEAs are not responsible for the provision of substance abuse treatment to a disabled student, even when the substance abuse interferes with the student's education and is intertwined with an emotional disturbance or some sort of other disabling condition. So solely substance abuse treatment programs is not a school's responsibility. But again, oftentimes we may have students who have these underlying mental health conditions who may also be engaging in substance abuse. And that is always the question of which came first, right? And is the student self-medicating because of an underlying mental health condition, which in many cases that may fall to the school district or the LEA to be responsible. One thing that comes up too with residential placements is, do we have to pay to get them there? Or what about therapeutic visits for the family to go visit the student? So generally, LEAs are going to be required to provide reasonable transportation expenses associated with the student's travel between the residential facility and home if we've made that our offer of free appropriate public education. At a minimum, LEAs need to figure out how to get them there safely and how to get them home at the end of the placement. Usually schools pay for transportation companies that may provide escort type services to get a student there safely. Beyond that, though, local policies that are based on individualized determinations should determine the frequency of the parents' visits to the placement, or even for the student to come home for a home visit. And that these policies, a lot of school agencies and SELPAs have policies regarding family visits and home visits, but it really does need to be done on a case-by-case basis as well. So hopefully your policies provide for that, and it really is based on the student's need and whether or not it's quarterly visits or every 6 months. That really should be an IEP team conversation about what does a student need in order to receive FAPE? Again, in terms of those visitations, so that those conversations and visitation terms should be part of the IEP process and documented in the IEP about what frequency and what the stipulations are regarding visits. This was a case example where the school had actually filed due process against the family in order to implement a residential placement over the parents' objection. So this was a 15-year-old student eligible under the category of emotional disturbance and had been placed there. Oh, I'm sorry, this is not the case. This was to bring the student back to a less restrictive environment. So excuse me. The student had been on a residential placement through the IEP process for about 2 years. The student's main area of need was social emotional related to impulsive behavior. The district was proposing an IEP where the student would transition from the residential placement component of the facility to living back at home, but that she would continue to attend the same non-public school. So the residential facility had a non-public school component. They were proposing to transition the student home, but to maintain the student's placement at the NPS. The parent refused to consent to the IEP, and so the district filed for due process to override the parent's lack of consent, seeking an order that its proposed placement was necessary for the student to receive FAPE. The district said that the student had made substantial progress on his goals, and behavior had dramatically improved since the student had first been placed in the residential program. For example, originally the student had suicidal ideations, tended to run away, and had headbanging behavior. But now, after being in the facility, was still engaging in some inappropriate behavior, but it was more limited to using profanity, making inappropriate comments, jumping on objects outside, or leaving an area without permission. But they were really concerned that continuing to maintain such a restrictive setting and not allowing the student to return home was actually detrimental to his well-being. And they really were concerned that he was risking becoming institutionalized because he was starting to languish in this restrictive setting that they did not believe at the district that he needed any longer. So the school won in that situation and did say that they had offered a free appropriate public education to transition him back to the non-public school setting and living at home. So some of these residential placements cases have argued that, well, there has to be some sort of transition and that the IEP has to document appropriate activities to support the transition from a more restrictive environment to a less restrictive environment. And interestingly, the education code does say, if appropriate, that an IEP shall include the provision for transition into the regular classroom if the pupil is to be transferred from a special class or non-public school into a regular class in a public school for any part of the school day, including a description of activities to integrate the student into the general education program and a description of those activities to help provide support to transition that student. Notably, though, that a lot of the court cases have said this is very specific when a student is moving from a special day class or a non-public school to a general education classroom, not necessarily a residential placement. So there wasn't anything specific in the education code about residential placement and having those activities to support the student. But I do think that there are a number of things for teams to consider when perhaps a student has been unilaterally placed in a more restrictive residential placement, or you are proposing to return the student to a less restrictive setting. So a few things to think about. You want to obviously address parents' concerns. Encourage parents to go visit the programs that you are proposing. Remind them that they can request an IEP meeting at any time if they think that the student is not making progress in the less restrictive program. Assure parents that you'll collaborate with the residential facility so that it helps prepare the student for that transition. Include staff from the residential program in your IEP meeting to really have a smooth transition. And you can even offer a designated person for parents to contact if concerns arise. You always want to emphasize preparation for the future, right? We're always trying to prepare students for the long term and life after post-secondary, in post-secondary life. So you want to explain how less restrictive programs can help their child prepare for life after school, and that maybe coming back to a district program or even a more local non-public school may allow the student to interact with mental health providers and other supportive services that are here within your community to help prepare them for independent living. And really think about what that transition plan could look like. You might consider offering a shortened day. So maybe the child would benefit from being placed in a less restrictive setting in the mornings at first and then adding more classes over time. Or you could consider a shortened trial period. So maybe we'll try it for 30 days, 60 days, and then we'll reconvene to review progress. Consider what related services may be necessary for the child. Counseling, which could be individual or group, or include family counseling, or even parent counseling and training. I've had several cases that have gone to hearing where we've actually hired experts to determine whether or not the district's offer of FAPE, which was a less restrictive setting than residential, was appropriate. And sometimes the missing component is that if the parent or the student returns home, they're going to maybe fall into some of those same patterns if there aren't good structures put in place or expectations that the parent, maybe the parent doesn't know how to work with a student who now has a disability and has anxiety and depression And so parent counseling or parent training is a related service under IDEA that is designed to help teach the parent how to have those skills to work with their child. And so that may be a good thing to offer, particularly if we're talking about transitioning a student back from a residential placement. You may also need to think about offering transportation because, again, perhaps the argument is, well, how are you going to get the student to attend school if it's in a less restrictive setting than residential? Oftentimes, if we are able to offer transportation, that may help alleviate some of those concerns. Consider making some appropriate referrals to various community resources. Consider whether placement in a group home or a foster family home prior to returning to the child's home would be beneficial. And so you would want to work with the students' social workers and that sort of thing. Consider the timing of the transition back to a district program based on the child's needs. Does it make sense to start this student, in the middle of a semester, or would it be better to do it at the start of the school year? Or maybe to do it during extended school year when maybe you're working on different things during extended school year. So consider the timing of that transition carefully. Obviously, we want to avoid predetermination, right? If a student was successful in a residential placement, then try to determine the reasons for the success, and maybe the district is able to replicate those supports in a less restrictive setting. Make sure we have updated assessment information to support any recommendations for an in-district placement. You may even consider, if the student has been unilaterally placed in a residential facility, you may even consider sending your school psychologist or whoever would be appropriate in terms of your service providers to go to the facility to be able to do their assessment, to gather information about how the student is doing, to really shore up the defensibility of your offer. Make sure parents have the opportunity to provide input. And of course, we want to make sure, if we develop any draft IEPs, that parents know that it's a draft and just a preliminary recommendation. And then ultimately make sure that your in district placement is appropriate. Again, it has to meet that FAPE standard of, is it reasonably calculated to allow the student to make appropriate progress in light of their circumstances? Even if the student would make more progress or faster progress in a residential setting, our obligation is to make sure that the student is able to make meaningful progress in light of their circumstances. And you may even consider hiring an outside expert to evaluate the child's needs and to make sure that the offer is appropriate, because that may be very beneficial in the event that you end up in some sort of legal dispute down the road. That's all I have for you today. Here's a link for our free legal alerts, and we will go ahead and stop the recording and take your questions.